Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of the Helfend Law Group and has spent more than 4 decades defending people charged with serious state and federal crimes across California. Over that time, he's seen how criminal cases often turn not on headlines or assumptions, but on what prosecutors actually can prove in court. I'm Evan Mack, and today we're breaking down what the prosecution really needs to prove in order to convict someone of a serious felony. Robert, sir, welcome back.
Thank you. Nice to be back.
Good to see you. But we're talking about like a serious felony case. But what is it the prosecution legally is required to prove to secure that conviction?
Well, I mean, that's like the most open-ended question you could ask me. I mean, do you want to pick?
Take it any way you want to take.
Charge or something? Let's talk about what kind of a charge do you want to talk about? What do they need to prove? They need to prove, look, every crime has elements to it. Okay. So I need to know what is the crime that we're talking about, because the way a jury trial works is the witnesses get on the stand, they testify what they saw, they testify what they heard. Prosecution, enters into evidence, different pictures, maybe some audio tape, maybe a surveillance video, and then, and everybody's subject to cross-examination. And then at the end of the trial, the judge reads the law to the jurors. And the law, when I say the law, there's elements. Mm-hmm. And so there's 1, 2, 3, 4 elements to a crime. And so as a defense attorney, you're basically saying, hey, element 1, yeah, that was there. My client did shoot him. Number 2, though, is usually a mental element. The mens rea is what it's called in legal jargon. And whether or not your client harbored the mens rea to be guilty of the offense. Did this person have malice when they stabbed the person? Did your client have malice when they shot the person? And so just taking that out of the air, that's, how you pick apart or you convince a jury that your client's not guilty is because they didn't harbor the mens rea that the prosecution needs to prove to find your client guilty.
So how does that the burden of proof shape the way a criminal cases are built and maybe defended?
Well, the burden of proof is always on the prosecution. And and that is beyond a reasonable doubt. And so it's a very high threshold. It's not 5150, like preponderance of the evidence is like 5150. Beyond a reasonable doubt means, I saw this, I believe the defense when he says, or she says, he didn't have malice when he shot the person or stabbed the person. Okay, I think, yeah, he's right. I'm not sure if this guy had malice when he did this. So I can't vote for guilty because I have a doubt. And so that's, if they have no choice, they have to vote not guilty.
So why is having the evidence not the same thing as proving a case beyond that reasonable doubt?
You got to put the pedal to the metal here, the rubber to the road. And even though something is written, you got to see how witnesses testify when they are at a trial. And that's really the difference. It's, how does this play out? One thing I in prior episodes, I've talked about this, and that, a trial, unfortunately, many times is not about the truth. It's about evidence.
Wow.
And the truth gets muddled when you have a trial. And because people, when they come to court, they might recant what they said, or, I have things that I'm able to present at trial, which impeach the witnesses. So impeachment evidence means that I'm attacking the credibility of a certain witness. And impeachment evidence is something that I am not required to give the prosecution before trial. And so I pull it out, when that witness is done testifying, I pull that out at trial. For instance, in a rape case, we talked about, I think I gave the example of somebody who filed a complaint saying, hey, we had sex all night. And in the police report, the person said, we only had sex once, and it was against my will, and I slept in another room. Well, the prosecution doesn't know about the complaint. I don't know why they don't, but they don't know about that complaint. And so, you're going to get on the stand and say this, and I'm going to give the prosecutor a copy of the complaint right before I show it to the alleged victim. Wait a minute, you said you had your lawyer file this, and if she says, well, I didn't, you mean you didn't read it before you had your lawyer file this? You filed this 3 years ago. You didn't know that your lawyer said that? So, meaning that the truth and evidence is a different thing. It's different. And it cuts both ways. It's not, I don't mean to say, the defense is sleazy and they hold back on this stuff I'm saying it cuts both ways as far as, wanting a prosecutor wanting a conviction versus wanting the truth.
So, Robert, what happens though when you see prosecution that they're relying heavily on these assumptions and inferences rather than that direct proof? What happens when it's just that, especially if I'm looking at the other side?
Well, you just hope that you're able to persuade the jury at closing argument that look at what they do here. Look at what the prosecution has attempted to do here. They've skewed this case by bringing in a witness that has nothing to do with this case. They've brought in an expert witness to talk about who knows what, to prove what, that my client had sex with this person. Their evidence doesn't prove that, but it's what they brought it in to in an attempt to bolster their case when their case, let's put it another way. You try to get your client, the prosecution, the police, try to get your client to admit to a certain crime.
Mm-hmm.
So what they do is they have a witness call your client on the phone with the police on the line, and so they're recording it. And so they make this phone call and the client says, I don't know what the you're doing. Oops. I don't know why you're making these accusations against me. They're not true. How about calling me back at another time and then we can talk about it. We'll talk about divvying up the house and custody of the kids later. But when you bring up this other shit, I'm not talking to you. Okay? So obviously that was a failure. So then they do it again. And this time, when the person brings up the same things, the client says, I'm just not going to answer. Okay? I'm not going to answer. I'm silent. Doesn't say anything. Now, when you get to trial, the prosecution wants to play only the second call and then argue, ladies and gentlemen, by Mr. X not denying it on the phone, he's tacitly admitted the crime. Wait a minute. What about the first one? You mean you're not going to play the first one? What about the first one when he said, call me later, call me another day? I mean, I'm not talking. I didn't do what you're saying I did. That is an example of a prosecution who's only interested in a conviction. Okay. So I believe your question was, what can you do?
Yeah.
To get around that. So that was an example. Okay. So I gave you that example.
Yeah.
Well, the first thing on an example like that you can do is, before you start a trial, you have basically motions in limine, I'll call them. That's what you call them in federal court. In state court, we use the evidence code number. So they're called 402, evidence code 402 motions. And so you have these motions in limine that you argue before you start trial, which is very important because that is a discussion. It's a hearing where the parties talk about what evidence can come in at trial and what can't. And so in a trial like that, you're arguing the doctrine of completeness to the judge, saying, Your Honor, he's not going to play, or she's not going to play the two recordings. He's only playing, or she's only going to play one. You either order that they can't play the second one, or order him or her to play both. Now, if the judge doesn't order the first one, I mean, it's sleazy, because the argument that the prosecutor uses is to play only one is, well, one has nothing to do with the other. One has nothing to do with the other one. They don't reference anything in the first one, so why would I play the first one? I only want the second one. There is a remedy to that, and that is to put your client on the stand, and then they all come in. Okay, then the first thing you say is, think about that if you're on a jury. I mean, just think about a trial strategy. Because what a prosecutor has done by doing only playing the second one, and then I put my client on the stand, and then I get the first one in, I can now look at a jury and say, ladies and gentlemen, why is the prosecutor only thinking about a victory? Why is the prosecutor only thinking about how do I convict this guy, and not about the truth? We're here to seek justice. You guys are here to seek the truth and justice. I'm the one who played you the first tape. I'm the one, not the prosecutor. He's hiding things from you. Why would somebody do that? Because he knows, or she knows, that the real evidence is going to hurt his case. And so, ladies and gentlemen, that's why you need to be suspicious of the prosecution and his case, because he's only showing you some evidence. He's holding the cards and holding certain cards close to the vest and doesn't want you to see everything. I'm showing you everything. And when I show you everything, that proves to you this never happened. So that's how you get around it. But it's difficult. I mean, think about that. Sometimes you don't have that. You don't have a way to counter things. It's terrible.
Yeah. So, but Robert, what should someone do though that's accused of a serious felony? Understand what should they understand about that proof, so they don't overestimate the prosecution's case, or maybe underestimate the risk that they might have when they go to trial?
Well, what it is it would be underestimating the power of the prosecution. So, any kind of a serious felony case, you need to work the case. You get an investigator for instance, I have a case where a victim made some allegations against the client, but the victim is kind of somebody, homeless, or this person, was with my client and wanted to have, would do anything to get some methamphetamine out of my client. So they decided to have, some fun together. And you give me the drugs and you can have fun with me. And then one thing led to another. So then police see them, and she all of a sudden changes her story and says, well, no, I didn't consent to anything. Okay. So what should a client do? Well, in that case, I had asked the prosecution, I want to make sure that you can contact this victim, because I don't think you can. I don't think this person's going to come in just because of who they are and the lies that they've shown. I don't think they want to go through a trial and be cross-examined by somebody. So they actually gave me the name and the phone number of this person. And so we've got the investigator now trying to call this person and try to see if they're, are they around? Are you gonna be there? And so, you need to work up a case. And so, if this person's going to show, if then the client has to weigh the risks of a conviction at trial versus what are you going to offer him or her before trial. Every kind of a case, not just that case. That was just an example of something, but everything is based on the evidence. And, if you went to trial, this is likely what will be shown at trial. Can you overcome what the prosecution is going to show at trial? And that's how you weigh whether or not you can win the trial or whether or not it's better to settle. And that's a very difficult question, because it depends on what the prosecution is going to offer you. What are they going to offer you before trial? So, and whether or not that's something, the trial is a very emotional thing for all the parties. It's emotional for me. It's all time consuming, and you're thinking only about tomorrow's witnesses, and you're thinking about your closing argument every time, because from each witness you are thinking what was important about their testimony and what should I highlight to a jury in the end to show that my client didn't do this. So the client also has to sit there for, a week or two. I mean, it's got to be, gut wrenching to sit there with the client. I mean, I can only imagine. I have people in cases, all different cases, and I say, well, do you want me to send you the police report? And they say, no, I can't read anything about myself. I can't read it. And I totally relate to that. I really do relate to that. I mean, even if I have a traffic ticket, it's hard for me to defend myself on a traffic ticket. It's because it's me. It's hard for me to do that for me because I get emotional about it. And when I read motions that, are opposing my clients or a position, sometimes it's difficult to read because they'll bring in something that I've said and counsel says, and it's very difficult sometimes because, I get pissed. What? Oh, I don't. So I really relate to a client when it's you. It's you they're pointing the finger at. It's you. And so there's a lot that goes into the decision to go to trial. Not only is it risky or risking more time in custody, possibly, a felony conviction
Mm.
when you go to trial, but it's gut-wrenching. And so you have to work with your client and decide whether or not it's, what's in their best interests, emotionally, as well as what are the collateral consequences and what are your chances at trial.
Alrighty, guys, that's it for today's episode of Criminal Law Unfiltered. Understanding what the prosecution must prove and where those cases often fall short is critical when you're facing serious criminal charges. If you'd like to learn more about Robert Helfend and the work he does at the Helfend Law Group, visit robertmhelfend.com. Thanks for listening, and don't forget to like, subscribe, leave a review, and share this with someone that might find it helpful as well. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.